Okay.
Hi, welcome to Oregon Law Lab. I'm Professor Liz Tippett
And I'm Jessica Brown. Today we'll be talking about race and IP law.
with Professor Kevin Green from Thomas Jefferson School of Law.
Well, thank you so much, and it's great to see you,
Great to see you.
Professor Green. And this is my research assistant, Jessica Brown.
Hi.
We're so excited to talk to you about your research today.
You likened Black artistry and creativity to Ralph Ellison, The Invisible Man. And so in regard to invisibility in terms of IP law, about how laws seem on their face to be, equal and helping everyone, but actually is disadvantaging us.
First of all, until it's only been 20 years, which is about how long I've been doing this as an academic, that there's been really any real exploration of the dynamics of race and gender in the IP space. And in the beginning, when I started doing this work, nobody else was doing it. I was literally heckled at conferences like AALS and attacked by people. Who said, why are you talking about this? And what's the relationship between race and intellectual property? There's nothing in the copyright law about race, which is exactly what you're pointing to. But of course, I drew on the work of some of the great critical race scholars who, showed in their work that the, subordination, as they say, can occur through these neutral concepts in the law.
I think it's also a common trope, in popular culture, like, oh, all artists are exploited by record companies, and record companies are, exploitative by nature.
Yeah, well, first of all, if you really study the American music recording industry, the two African American women, Mamie Smith in 1920 with Crazy Blues, and then later on Bessie Smith, demonstrated that there was a real market for sound recordings and that people wanted to buy them. It started out in the African American community, and it went out from there. But I believe that the American music industry was built on the backs of African American artists, and the contracts, unfortunately, spill over to affect all artists. So when people say that, they don't realize that we had these race record divisions, we had these egregious contracts. Well, of course, if it worked for the Black artists, why not use it for everybody if we can make this money?
I wanted to actually ask you more about Bessie Smith. Can you tell us what happened to Bessie Smith's IP rights?
Sure. Well, Bessie Smith, of course, was considered the Empress of the Blues, the greatest, certainly female singer, maybe any male or female of all time. Extremely influential on the music that we listen to today, which a lot of people don't realize that it's all based on the blues idiom. During her lifetime, she made significant amounts of money. I saw one figure that she made in 1 year made $100,000, which would be equivalent to a couple of million, 3-4 million. But the problem is that she was signed to flat fee deals. So the only money she made was from the contract. She didn't own or control her copyrights. You guys saw the movie Cadillac Records, where the practice of the American music industry for African American artists, rather than paying them royalties, which could last under copyright for the life of the author plus an additional 70 years now, in other words, a very long time, they would just be given a Cadillac. So they'd sign a contract, get a Cadillac, and someone else was controlling those rights.
I remember discussing one all year the Vanna White case in regard to like her suing for her likeness.
Yeah.
And so I was wondering why that isn't, or like if that is a good avenue to try to take, because a lot of performers do end up doing similar dances or like voice sounds or just things like that that make them who they are and recognizable to people, like Cardi B, for example. So I was wondering if that was a good avenue to take.
I mean, I think that's a great question. I think lawyers are now trying to get this figured out. You might have heard about this rash of lawsuits against video game companies, such as EA, and some people who've done dances have tried to sue them. Carlton, I think, from the Fresh Prince sued, and another guy called Millie, or 2 Millie, who does a dance called a Millie Rock, he sued. These are not faring well because copyright has something called preemption. And so if it's an equivalent right, it's going to be preempted. And the right you're talking about in the Vanna White case is the right of publicity, which could give some protection to performance. But if it comes in the copyright case, it's probably going to be dismissed. In those cases, by the way, the first court that ruled on this, they ruled against the rapper, rather the actor Carlton, they said that the dance that you do isn't protected under copyright because choreography is protected. However, choreography is based on a European motif of ballet. That's the classic thing that can be copyrighted. Once again, what African Americans do somehow ends up not being protected.
Can we talk a little bit about reparations? You speak about how IP may be best suited, just based on its structure, to receive litigation regarding it and distribution of funds.
Sure, I thank you for raising that. Well, in retrospect, I think that piece was kind of more of a thought piece.
Mm-hmm.
So I just want to be clear. I don't think there'll be reparations ever for anybody.
But I like that piece. Stop discounting your piece. I like that one.
Because reparations is extraordinarily unpopular, on the American public generally.
Mm-hmm.
But yes, if we were going to have reparations, it would be easiest to do in the space of music and creative arts. And the reason is that there are records. There aren't records of my family and on my father's side who were slaves and who owned what, are not very strong records anyway. Right now, there are about 4 companies that control all the music that you hear in the world. And so we can actually go back and see who's getting paid. To me, reparations made sense because copyright lasts a long time, right? It's the author's life plus another 70 years. We could be talking about 140 years or more of copyright protection. And a lot of that old music is incredibly valuable because it can be recycled, it can be used in commercials, it can be sampled. And we still don't know who's getting paid what for that music. Roy Brooks, this is the work of Professor Roy Brooks. He says every reparations, whether it's for Japanese Americans or Jewish Americans or Indians, Native Americans, it all starts with an apology. And so far, I would like to see, my dream for reparations, quote unquote, would be to see the American music industry and Hollywood apologize. Where not only the exploitation of African American artists and performers and expropriation of their art, but also for the derogatory stereotypes which were promulgated under those. That has not happened, and I think that would be worthwhile to have them say, yeah, you know what, we're really sorry that we did this. We're really sorry we treated these artists this way.
Oh, okay. I have one more question.
Sure.
Do you think like great ideas are like scarce or not scarce?
Well, people say ideas are a dime a dozen. And so I tend to think that, yes, really, powerful, valuable ideas were probably not all that common. And the problem with most of these people in the idea misappropriation space is they have one good idea and it gets appropriated.
Yeah.
Now, the unwritten rule in Hollywood is if you do come up with that idea good enough to be appropriated by a major producer studio, then you'll have our ear the next time. In other words, the second go round, or the freebie rule. You have to give us a freebie. And then after that, we'll think about compensating you. Yeah.
But if you only have one, what good is that?
If you only have one, that's it. And if you look at most of the idea misappropriation cases and the plaintiffs, you can't find them on the internet having done anything. They never actually have another project that goes anywhere.
Wow.
Yeah.
Then that's a highly convenient rule for the studios. They know that you
Right.
only have one great idea too. They want your best idea.
I mean, they would have a different perspective. Obviously, they said, look, we have this business with this tremendous overhead. We have this business where only one, sometimes only 0.5 of 10 projects is going to make it. I kind of question that. They were extremely profitable,
Right.
uber profitable. So
Well, this was super fun.
it was fun. Yeah,
I
I
love
loved your
hearing
questions.
all of your thoughts on all these questions. I feel like you have a lot of great ideas, not just one. Choose who.
No, it was a lot of fun. I was happy to do it. Thanks so much.
That concludes our video. Thank you for watching.
And be sure to like and subscribe the video.
Why did you start laughing?
I can't say like and subscribe. That doesn't even make any sense. Like,
Yes,
I feel
it
like-
does. They're separate things.
I feel like they could choose one, and I'll be happy with that if they just choose one.